Okay, we're recording.
All right. Good morning, gentlemen.
Morning.
Morning, Mr. Sampson.
I have a hard stop at 10:45, which I think should be sufficient time for this deliberation, 45 minutes. But if it's not, we'll address that if we get to that point. I think the best way to start is I'm going to summarize a statement of the case, how I want to proceed, discuss the applicable law and the standard, then jump to where I am based on my own review and consideration, what I propose, and then let's see where the two of you are, and then we'll go deeper as we need to. So I think Mr. LaFiandra provided the most succinct statement of the case. The petitions for zoning hearing in this matter seek a special exception for a landscape service operation and a variance for an internal roadway to be located 0 feet from a property line in lieu of the minimum required 25 feet. The petitioner, Greg Mangum, is the owner of the subject property located at 14100 Longnecker Road. The administrative law judge granted the relief in a decision dated April 15, 2022. There was also a corrected decision. The adjoining property owners, Ben and Molly Smith, appealed to this board and pursuant to Baltimore County Code Section 603, this board hears and decides this case de novo. To that end, a de novo hearing was held over 3 days in October and December of 2022. Both the petitioner and the protestants were represented by counsel, and at the board's request, the parties submitted written briefs in lieu of closing argument, and I found them to be very helpful, both very well written, very detailed, and unfortunately, as the nature of there's challenges here for us to resolve, and in all likelihood, someone is going to feel unhappy with our result. But we're guided by the applicable law and the facts as we record are quite voluminous and not necessary to recite for us to deliberate. We'll address any material facts that we've considered or anyone else in our panel here raises. And then, of course, our written opinion and order will contain a more detailed and concise statement. So as I understand it, the applicable law and standard of review is as follows. A special exception and variances may be granted at the same time. Court in Albiani versus Dixon held, in granting any special exception, the board is governed by the principles and conditions in BCZR 502, specifically 502.1, which enumerates a number of specifics A through H, which I'm not going to recite right now. But the bottom line is we have to find that those are not, before any special exception may be granted, it must appear that the use for which the special exception is requested will not do those things itemized. I find it will not. The RC2 regulations also require additional findings by the board in its evaluation of the special exception standards in 502.1. These include, first, this board must find that the use would not be detrimental to the primary agricultural uses in its vicinity. I find it is not. Board must also find that the landscape service operation satisfies the provisions of section 404.1 and 404.3, which contain specific regulations applicable to landscape service operations. I find that it does. I find that this proposed use meets the definition of a landscape service operation. In addition to those, our review of a special exception is governed by Schultz. Both parties cite it. There's some attempt to distinguish or apply it. But what I find most important is that it adds language to the statutory factors to be considered in evaluating proposed special exceptions. It's not separate. And in that case, the Court of Appeals, now I guess the Maryland Supreme Court, articulated a standard for addressing the degree to which a proposed use's adverse impact affects the outcome of a special exception request. And it recognized that a special exception use by virtue of its inclusion in the comprehensive zoning plan, is presumptively valid unless there are strong and substantial existing facts or circumstances showing that the particularized proposed use has detrimental effects above and beyond the inherent ones ordinarily associated with such uses. Here I find there has not been any showing sufficient to overcome the presumptive validity of Schultz. Finally, in granting any variance, the board is governed by the authority codified in BCZR 307.1 and Cromwell. I find the property meets these requirements. So turning to the deliberation more specifically, we must evaluate the special exception and variance relief requested and determine whether they are supported by competent material and substantial evidence. As I already indicated, jumping from the applicable law to my conclusion, I find that they do. And I've already indicated that I find that the proposed use meets the definition of a landscape service operation. So where that takes me is both parties submitted, and certainly the Smiths don't want any of this to happen. I recognize that. Alternatively, they have indicated that if the board is inclined to not agree with them, that they have proposed certain conditions 1 through 11. Mr. Mangum also, in seeking this court to approve what he is requesting, he has included 10 proposed conditions, and I've attempted to sort of distill them and determine what I think makes most sense. So while I find that the evidence does support a finding that the conditional special exception approval and variance approval should be granted, I'm agreeing first with the petitioner that the testimony and evidence produced by the protestants regarding alleged violations within the forest conservation and forest buffer easements, the impact of the grading and filling on the previously approved septic reserve area, and the need for Maryland Department of Environment approval of Tier 2 water body discharge are not before this board at this time. So I don't see anything more to do there. But I will agree further that we should be placing the following conditions on our approval, or at least as I propose it, which is basically to agree with all 10 of Mr. Mangum's, and which I can read, but just for the moment, all 10 of those, and basically all proposed by the Smiths except for 1 and 2, which I believe are addressed adequately, at least within the contours of the decision I would render, in Mr. Mangum's proposed number 1. And I also don't think that number 6, requiring the driver's license of the employees, is appropriate or necessary. So, to summarize, then I would take Mr. Mangum's 1 through 10 proposed conditions, and I would also add 3, 4, 5, 7, 8, 9, 10, 11 from the Smiths, and I think that those are consistent and reconcilable. What the Smiths essentially add to what Mr. Mangum has not, which I think are appropriate, would be number 3 is that, well, maybe I should just read them all after we get to what you gentlemen think. So I don't know how clearly that's articulated. I've got plenty of analysis I can do applying the facts to the law under all the conditions to tell you how I got to where I did. But let me ask where each of you are. Maybe we're unanimous, maybe the 2 of you disagree with me entirely, maybe there's more to hash out just in terms of specific conditions, or so who wants to go first between the 2 of you?
Sure, I can go. In summary, in a nutshell, Mr. Sampson, I agree with you. As far as the special exception, not to rehash everything you said, but I went through, I basically made a flow chart. 502.1 went through all the factors there. Let's see. Sorry, gentlemen, my fax machine's ringing right behind me. I went through, and then the 1AO 1.2 C factors, went through those. And then the Schultz v. Attar, I think it's satisfied. I agree with you, Mr. Sampson. I think the petitioner satisfied all of that. As far as a variance, I agree the property is certainly unique in that, and there was all the testimony about the inability to farm the area, and the way it's shaped, and obviously with the way the driveway has to be through another property. And I just going through, and it's obviously the second part of the variance, the practical difficulty, undue hardship, I think is satisfied. So I agree with you there. And I guess I can go to Mr. Lauer first. I mean, if we want to start talking about the conditions, I guess we hear what you have to say first, and then we go through the conditions.
Sure. First of all, Mr. Chairman, I think you did a great job with the hearings, and also summarizing and applying the law and putting it in context here to what we're discussing. My feelings are, in my notes here, basically, I feel that they meet the Schultz and the Cromwell standards, both for special exceptions and the variance. I was kind of scratching my head and looking through this, and if not the landscaping business, I don't know that the owner of the property would have any use for this, and there would be objection to everything. It kind of is what I felt as we went through the hearings and summarized stuff. The other thing that I would point out in looking through it, there are a lot of objections, or some objections, related to the future permits that need to be gotten related to the buffer zone and other things. And I don't think those are things that we need to address. I think those come down the road, and those will go through the administrative process. But I would agree completely with both of you where we are at this point. I do have the list of the conditions by the parties, both Mangum and other parties here. So we can either go through them, but in general, I would, in looking through them, wouldn't see any problem with your proposal, Mr. Chairman, with adding the Magnum 10, if you will, and then the other, 7 from the Smiths, or this case. I
Okay,
think there's 7. Yeah, 7.
Mr. Pennington, where are you on the conditions to be imposed?
Where I am is, I'm just having a bit of an issue. Maybe you gentlemen can flush it out for me. I'm having a bit of an issue with protestants number 7. And I believe Mr. Mangum testified about this. Conduct any landscape service operations of any description on the subject property on Sundays. And I believe he testified that. I mean, how do we define that? Because he testified that he goes to the property, or he used to, on Sundays, to do work around the property. Is that considered conducting a landscape operation? I mean, I don't think we should prohibit somebody from going and doing work on their property, as long as they're not doing commercial work. So that's, it's tough it'd be tough to word that, but I think the intent, in my intent would be, yes, Mr. Mangum, you can go to your property on Sundays. How can we tell you not to? But you can't conduct business on Sundays.
Well, the only problem I see with that, Mr. Pennington, is he did say that in emergency kind of situations, sometimes they may need to come in on a weekend. So I'm glad you pointed that out, because I kind of brushed through it, and I don't know how we and I assume that doesn't happen very often, but there could be occasion where they need to address that. So I don't know. I'd look for guidance from you two of how to kind of fill that gap, if you will.
Well, on the one hand, the easiest way to do it would be to enumerate the prohibited operations. But in theory, that's easy. In practice, I don't know that I'm equipped to do that. It may be that in reviewing the transcript, I can better isolate, because I don't have it in my notes or my memory precisely where this disagreement is. But I agree with your point. The language is pretty loose. We have landscape service operation defined in the code as an operation primarily engaged in the designing, installing, planting, or maintaining of lawns, gardens, or other plantings at off-site commercial or residential uses. So the question is, what's he do on Sunday on the property that relates to what he's going to do Monday through Saturday off the property in conducting his landscape service operations? And yeah, there is. Can he take delivery of material on site Sunday to distribute Monday through Saturday, for example? I think that's what we're talking about. I think that's the point you're raising. And clearly the intent, which is never sufficient, the spirit rather, of what we're doing is to say, hey, look, let's make an accommodation to your neighbors, give them peace and quiet all day on Sunday, vis-a-vis what you're going to be doing for your landscape operation. He could still be, without doing a landscape operation, he could operate tractors all day if he wanted to. And that's noisy and smelly. So you raise a great point. You're correct. I want to work something into that, but I'm not sure how precise we can be.
It's tough. I mean, I can see what Mr. Mangum, he testified about sometimes for, as Mr. Lowry referred to, emergency situations, whether there's snow, where they need to, do snow removal, or whether there's bad storms where his service is needed. If there's a bad storm on a Sunday, he shouldn't be prevented from, clearing roadways and doing, things akin to, storm cleanup. So I don't know. I don't know how to word it. I mean, maybe you can't conduct regular business operations on a Sunday. If there's emergency, then perhaps, you can do the snow removal or the tree removal.
Okay. So as to the proposed Smith number 7, we agree that it should apply, but we need to further restrict or define it. And I don't know that we're required in this deliberation to get to that granular language, but if we are, what we'll say for now, I don't think we are, but what we'll say for now is we have to revise the of any description. So shall not conduct any landscape service operation as defined by whatever I said that section was, BCZR 101.1, remove of any description, and then put this shall not include emergency services. I don't know about emergency services related to some emergency services such as snow removal, well, I don't really know, such as clearing roads, or because this isn't done on his property though. What are we talking about when we say, are we talking about driving trucks on and off his property to get somewhere else?
Yeah,
Okay.
Yeah, that's what I would think. Or is people coming in, reporting there, and then getting on trucks and going and doing whatever they're doing, you know?
right. And then coming back like for storm cleanup, and then coming back with the tree branches and offloading.
Right.
So, okay, petitioner shall not conduct any landscape services operations as defined by BCZR 101.1 on the subject property on Sundays, with the exception of emergency-related services to clear snow or debris roadways. I mean, that's gonna raise a question, well, what if it's a driveway? What if somebody needs my driveway, their driveway cleared? Roadways, driveways, or access roads. And then I think we can say, unless otherwise agreed in writing by the parties. I'll work on that. Okay, that's number 7. Okay. Any other discussion on conditions?
I do actually have I have a question about condition number 11.
Okay.
I don't, now, you gentlemen have been doing this longer than me, but to me, it seems like to amend a minor subplan through development review committee, that seems cumbersome. Am I not right in that?
It seems what? I'm sorry, I didn't hear you.
It seems cumbersome time, and it seems like it takes a while to do that.
Well,
Right.
so
Is that
we
true?
can remove, yeah, we can remove before any commercial use may be made. We can just have a condition that he has to apply to amend it. 'Cause
That
I
sounds
think what you're saying is you're not concerned about the application, you're concerned about it impeding his ability to begin the
correct.
commercial operation.
Correct.
So let's just strike that first part and begin it with the petitioner shall apply to the development review committee to amend the minor subplan to remove notes 7 and 19 and to show the proposed improvements thereon. Do we want to impose a time frame by which he must do it, and shall apply within, I don't, 90 days, 120 days, a year?
I don't know that we need a time frame, Mr. Chairman. I mean, they can do it whenever. I assume they want to move ahead with this project.
All right, those are great points, Mr. Pennington. Others? Gentlemen, satisfied with the other conditions?
I believe I am, Mr. Chairman.
Mr. Lauer, do you have any others?
I do not, Mr. Chairman.
Okay. Do we need to discuss anything further on this matter?
I don't have anything else, Mr. Chairman.
No, I don't have anything either.
The written opinion will address in more detail the specific findings that we've discussed generally. And again, as I said, both parties did a superb job in putting in writing the facts on which they rely, the facts that support their argument, likewise with the law that supports their argument. And the three of us in reaching our decision separately, obviously from our discussion here, have already undertaken that individual analysis to reach our conclusion. And so the statement will just adopt, I anticipate will adopt the factual support where appropriate from those briefs, meaning they've already done the work of putting it in writing, because they're both so detailed, as opposed to necessarily us having to just go find them for ourselves. But I can just tell you, I've got 25 pages here of my analysis that is already done to support the conclusions that I've given. So if we don't need to do anything further and discuss those now, then I think we can adjourn. Is there anything else either of you want to mention?
Not here.
I don't have anything else, Mr. Chairman. Thank you very much. Great job.
All right, thank you both for your
Thank you, sir.
preparation. They go smoother when we all are able to prepare. It's obvious. I'm interested to see your flow chart, though, Mr. Pennington. Sounds impressive.
I have to flush it out. It's right there.
Nice. All right, Mrs. Honor, is there anything that you're aware of that we need to further address?
No, sir.
Okay, great. Well, thank you all. Appreciate it. Have a good day.
Okay.
Thank you, sir.
Thank you.